My name's Daisy Jones. I'm an associate in the employment team at Fox Williams, and I'm going to be talking about collective redundancy consultation. Where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a 90-day period, it will be required to go through a collective redundancy consultation process. This will require the employer to inform and consult with appropriate representatives of its affected employees and also to make a notification to the Department of Business, Energy and Industrial Strategy. Employers often become quite exercised about collective consultation obligations, and I think the principal reason is because of the expense that can be incurred if you get it wrong. If you fail to collectively consult with your affected employees, then you could be liable for a protective award of up to 90 days gross pay per affected employee, and failure to make the notification to the Department of Business is a criminal offence with a potentially unlimited fine. There can be many tricky issues which arise in the context of collective redundancy consultation, but I'm going to pick up on 5 with you today. Firstly, the definition of redundancy for the purposes of the collective consultation regime is wider than your classic redundancy definition. The definition of redundancy in this situation applies to any termination where the reason is not connected to the individual employees. This means that it can apply to situations such as changing terms and conditions of employment, where an employer decides to terminate and re-engage those employees that don't agree to the changing terms and conditions. In these circumstances, where there are more than 20 employees to be terminated, the collective consultation regime would apply. Secondly, the obligation is to consult with appropriate representatives of affected employees. Now, affected employees are any employees who are impacted by the redundancies and may include those whose roles themselves aren't at risk, but whose jobs could be impacted by the loss of others around them. As such, it's important to remember this population of people when you're going through your collective consultation process. Third, consultation must be undertaken with a view to reaching agreement with the appropriate reps. This means that an employer has to go into the consultation process with an open mind and be prepared to consider any alternatives or mitigation suggestions put forward by the representatives. If you fail to reach agreement with the appropriate representatives, this won't mean that your consultation process is flawed, provided that you've gone into it with an open mind and given proper consideration to any suggestions put forward. Fourth, clients often seem to think that the consultation process itself has to last for the 30 or 45-day period set out in the legislation. This isn't correct. The 30 or 45-day time limit is the period of time that needs to elapse between the commencement of the consultation and the first dismissal taking effect. It could be that the consultation doesn't last the full 30 or 45 days, and this in and of itself is not a problem. Finally, just because you've gone through a collective consultation process, it doesn't mean that you can ignore the individual consultation process which will need to follow. The individual consultation process is the step which gives you protection against unfair dismissal claims, and as such, it's important that you build this into your timetable when you're thinking about collective redundancies.